In the earlier sections of this chapter, you learned what an agency relationship is, what fiduciary duties arise from it, and the different forms agency can take in real estate practice. The next step is making sure that everyone in the transaction actually understands those relationships. Agency disclosure rules exist to answer one simple but critical question for consumers: who is your loyalty to? In Arizona and nationally, failure to disclose agency properly is one of the fastest paths to complaints, lawsuits, and ADRI discipline. This section ties the national concepts of disclosure to Arizona's specific rules, cases, and policy statements so that you can recognize when and how to disclose, what must be revealed, and where your duty to investigate ends. Objectives of disclosure. The core purpose of agency disclosure is to remove confusion. Consumers should never have to guess who their agent represents, whether the agent owes them fiduciary duties, or what choices they have for representation. Modern statutes and commissioners' rules turn what used to be an ethical best practice into a legal requirement. Disclosure aims to accomplish several things at once. First, it notifies both clients and customers which party the agent represents and which party the agent does not represent, unless there is a properly disclosed dual agency. Second, it explains the basic fiduciary duties and standards of care owed to the represented client versus fairness and honesty owed to the non-client. Third, it puts prospective buyers and sellers on notice that they have representation options, including buyer agency, seller agency, or in some jurisdictions, no agency transaction brokerage. Finally, disclosure creates a written record that the parties understood and accepted the agency relationships before the transaction moved forward. Proper disclosure is required whenever there is a transfer of a real property interest, whether fee simple, partial interest, exchange, leasehold, sublease, assignment, or even specialized interests such as air rights or subsurface rights. Seller-agent disclosures. When an agent plans to represent a seller or landlord, disclosure begins with the prospective client. Before the listing agreement is executed, the agent should explain in writing that the broker will represent the seller's interests as a fiduciary and will not represent any potential buyers in that transaction unless there is a properly disclosed and consented dual agency. The listing agreement itself and subsequent purchase or lease contracts should be consistent with this disclosure. Beyond simply saying, "I represent the seller," Arizona imposes specific disclosure duties on listing brokers. Under Arizona common law and ADRE commissioners' rules, a listing broker must disclose all offers to the seller as required by AAC R4-28-802B. The broker must disclose information indicating that a buyer may be unable to perform, as recognized in Mason v. Bolleri and incorporated into AAC R4-28-1101B. If the broker, the broker's family, or a business entity in which the broker has an interest will be the buyer, this must be disclosed in writing under AAC R4-28-1101E. Any compensation, rebates, or profits the broker receives related to the transaction must be disclosed and consented to in writing under AAC R4-28-1101G. Finally, the broker must disclose the name of each employing broker receiving compensation from the transaction as required by AAC R4-28-701. Seller-side disclosure also extends to buyers and tenants as customers. A listing agent must disclose in writing to a buyer or tenant that the agent represents the owner in the transaction. This must occur no later than the first substantive contact, and the relationship should be confirmed in the sales or lease contract. The goal is to avoid the common consumer assumption that the person helping me must be my agent, when, in fact, that licensee owes fiduciary duties to the seller. Substantive contact, exclusions, And oral disclosure, substantive contact, is the trigger point for many agency disclosures. Although state definitions vary, the concept is largely consistent. Substantive contact exists once the licensee goes beyond casual conversation and begins showing property, seeking or receiving confidential information about a prospect's needs, motivations, or financial qualifications, or helping the prospect write or negotiate an offer to buy or lease. Not all interactions count as substantive contact. Simply attending or supervising an open house, so long as the agent does not probe for confidential information or begin discussing representation, is often excluded. Light, preliminary, small talk about general price ranges, neighborhoods, or architectural styles is typically not substantive. Brief answers to factual questions about an advertised property, such as square footage or list price, may also fall short of the threshold. However, once the conversation moves toward advice, negotiation, or confidential information, the agent must treat the interaction as substantive and provide the appropriate disclosure. Sometimes, first substantive contact occurs before the parties meet in person. If an agent is having a substantive conversation over the phone, via video call, or in another setting where written disclosure is not immediately practical, the agent should disclose agency orally at that time and then follow up with written disclosure at the first face-to-face meeting, or as soon as feasible. The critical point is that by the time consumers are sharing confidential information or writing offers, they should clearly know who the agent represents. Buyer-agent disclosures. Buyer's brokers follow a parallel structure. Before a buyer-broker or tenant representation agreement is signed, the licensee should explain in writing that the broker will represent the buyer's interests as a fiduciary and that the seller will be treated as a customer. The agreement itself should reflect these disclosures and outline the broker's duties, compensation structure, and in Arizona, stigmatized property rules and dispute resolution provisions. In practice, there are identifiable disclosure obligations owed to buyers. A buyer's broker must disclose all known material defects existing in the property under AAC R4-28-1101B3. If the seller is or may be unable to perform, the broker must disclose that information under AACR 4-28-1101B1. If there may be liens or other encumbrances on the property, this must also be disclosed under AAC R 4-28-1101B4, where the broker, the broker's family, or a related entity is the seller. This interest must be revealed under AACR 4-28-1101E. As with listing brokers, any compensation, rebates, or profits received by the buyer's broker must be disclosed and consented to in writing under AAC R 4-28-1101G, and all employing brokers receiving compensation must be disclosed under AACR 4-28-701. Buyer agents must also disclose their agency status to the seller or the seller's agent at the first contact, which is treated as substantively significant. This prevents misunderstandings, especially in markets transitioning away from sub-agency models, and helps listing brokers understand whether they are dealing with a customer or an opposing fiduciary. Dual agent disclosures. Dual agency adds a layer of disclosure complexity because the broker is attempting to serve two clients whose interests may conflict. In states that allow dual agency, including Arizona, the law requires informed written consent from both parties before the broker can act as a dual agent. That consent is not a formality. It should be based on a clear explanation of what duties will be limited and what protections remain. Informed written consent means both buyer and seller have read, understood, and signed a dual agency or limited representation disclosure acceptable under state law and commonly reinforced by realtor association forms, such as the consent to limited representation. The initial consent should be obtained before the dual agency relationship is created, not after the offer is submitted. Subsequent contracts should confirm the disclosure and maintain consistency with the consent form. Once dual agency exists, state rules generally prohibit the broker from making certain disclosures without explicit written instructions. The dual agent typically may not tell the buyer that the seller will accept less than the list price, nor tell the seller that the buyer will pay more than the offered price. The agent may not reveal one party's confidential motivations, bottom line positions, or willingness to alter financing terms. Again, unless the affected party has authorized specific disclosure. The dual agent must still disclose material defects and information that materially and adversely affects consideration, but may not use confidential information to give one party an advantage over the other. Facilitator and transaction broker disclosures. In jurisdictions that recognize a transaction broker or facilitator role, disclosure focuses on clarifying that no agency relationship exists. The transaction broker does not owe fiduciary duties of loyalty and confidentiality in the same way an agent does. Instead, they owe duties of honesty, fair dealing, reasonable care, accounting, and disclosure of material facts. Disclosure rules for transaction brokers are similar in structure to those for dual agents. The broker must provide written notice to all parties or their agents upon first becoming a transaction broker, or at the first substantive contact, whichever occurs first. This notice should clarify that the broker will assist both parties with the mechanics of the transaction, but will not advocate for either as a fiduciary. As state regulatory frameworks evolve, many require written acknowledgement from the parties to avoid confusion and liability. Practical disclosure guidelines. Agency disclosure is only one part of the broader disclosure picture in a real estate transaction. Property condition, defects, environmental concerns, airport noise, and even surrounding criminal activity can all raise questions about what must be disclosed, who must disclose, and how far a broker's duty to investigate extends. A useful set of practical guidelines can help brokers meet their disclosure obligations and show reasonable care. If you actually know of a material defect that affects value and is not readily observable, you must disclose it. If you are unsure whether a fact is material, the safer course is to disclose or, at minimum, encourage investigation. When you observe a suspicious condition, such as water staining or structural cracks, you should point it out and recommend further inspection by a qualified professional. If you or your client questions the accuracy of information provided by the other side or by third parties, you should assist in verifying that information. If your client asks about a topic beyond your expertise, such as structural engineering, legal rights, tax consequences, or environmental hazards, you should direct them to an appropriate professional and document the referral. When you pass along information, you should identify the source. Use tools like the AAR Seller's Property Disclosure Statement, recommend home inspections, and educate clients about their own obligations to investigate. Above all, document your disclosures, verifications, and recommendations in writing to create a clear record. The scope of a broker's duty to verify. A recurring question in practice is whether a broker must independently verify every piece of information in a transaction. The ADRI addressed this in Substantive Policy Statement 2005.13. Licensees are real estate professionals with fiduciary duties under R4-28-1101I and must act in their client's best interests. Reasonable care may include recommending that the client seek professional advice in areas where the agent lacks expertise. Licensees are expected to take reasonable steps to help clients confirm or verify information when a reasonably prudent real estate professional would question its accuracy or when the client has expressed concerns. This does not mean you must become an appraiser, engineer, or environmental consultant. It does mean You cannot intentionally ignore potential sources of adverse information to avoid disclosure. For example, a bank may instruct an REO listing agent not to read inspection reports from failed contracts so the agent can claim ignorance. Under Arizona law and negligent misrepresentation principles, that strategy fails. An agent cannot willfully turn a blind eye to inspection reports and then claim there was no duty to disclose. If a report identifies a material defect, an agent who fails to review and disclose that information before closing risks liability and discipline. Special Arizona disclosure topics. Arizona law includes specific disclosure requirements for certain location-based issues. Properties in the territory in the vicinity of a military airport are subject to disclosure rules found in ARS. Perf. 28-8483 and 28-8484. Public airport vicinity disclosures are governed by ARS Section 28-8486. Noise contour and flight path maps are available through ADRE's airport map resources, and prudent brokers familiarize themselves with these tools to assist buyers in evaluating airport-related impacts. Criminal activity and stigmatized property also present disclosure challenges. Under Hill v. Jones and AACR 4-28-1101B, sellers must disclose all known facts that materially affect value and are not readily observable, and listing brokers must disclose information that would materially affect the consideration paid by a reasonable buyer. If the seller or listing agent has actual knowledge of criminal activity in the surrounding area that materially affects value, that information must be disclosed. Rumors and speculation, however, do not create the same obligation. Even so, a broker may choose to disclose rumors in an abundance of caution while carefully labeling them as unverified. By contrast, Arizona's Stigmatized Property Statute, ARS Section 322156, provides that failure to disclose that a property is or has been the site of a natural death, suicide, homicide, or other felony cannot result in liability. Similarly, there is no obligation to disclose that a property was occupied by a person with HIV/AIDS or is near a sex offender. Actual criminal activity in the neighborhood that materially affects value may require disclosure. Stigmatizing events at the property itself generally do not. Finally, not every piece of negative information is a required disclosure. An appraisal is an opinion of value, not a fact materially affecting the transaction. Even when the seller pays for the appraisal, the lender is the appraiser's client, and federal law requires the lender to provide a copy to the applicant buyer, not the seller. The Arizona Residential Resale Purchase Contract does not require the buyer to disclose the appraisal opinion to the seller, and Lombardo v. Albu makes clear that opinions of value are distinct from facts that materially affect the transaction. Buyers still have a duty to disclose known facts materially affecting the transaction, but they are not obligated to hand over the appraisal report itself. Review summary. In this section, you examined how agency and property disclosures operate together to protect consumers and reduce disputes. Agency disclosure rules exist to clarify whom the agent represents, what duties are owed to each party, and what choices consumers have for representation. Listing agents must disclose their fiduciary role to sellers, their non-representation of buyers, and specific legal obligations such as presenting all offers, disclosing buyers' potential inability to perform, revealing their own interests in the transaction, and identifying all brokers receiving compensation. Buyers' brokers must mirror those obligations on the buy side, disclosing known defects, seller performance concerns, liens and encumbrances, financial interests in the property, and compensation arrangements, while also telling sellers and listing brokers that they represent the buyer. Dual agents must secure informed written consent from both parties before acting and are heavily restricted in sharing confidential information or advocating for one side at the other's expense. Transaction brokers or facilitators, where recognized, must disclose their non-agency status and focus on honesty, fair dealing, reasonable care, and disclosure of material facts without providing fiduciary loyalty. Across all forms of agency, practical disclosure guidelines emphasize disclosing known material defects. When in doubt, leaning toward disclosure or investigation. Using formal tools like the seller's property disclosure statement, recommending professional inspections, and documenting all advice and disclosures in writing. Arizona-specific topics, such as airport vicinity laws, criminal activity versus stigmatized property, the duty not to ignore inspection reports, and the non-required disclosure of appraisals illustrate how nuanced disclosure can become. As a licensee, mastering these rules helps you fulfill your fiduciary duties, avoid negligent misrepresentation, and guide clients through complex transactions with clarity and integrity.